Day, Todos Hamsu. Very delighted to have Neil Weare here for our 42nd presidential lecture. Thanks to everybody involved in creating the lecture, and so happy to have Neil back home after a number of years of not being able to be back home. And of course, delighted to have our Chief Justice and our Attorney General here as well as everyone in the audience and online. So I'm very pleased to introduce Neil Weare, and as you may already know, he's a civil rights attorney and nonprofit leader committed to addressing America's colonies problem. Raised in Guam, Neil graduated from Southern High School and earned a Bachelor of Science in International Affairs at Lewis and Clark College in Portland, Oregon. He worked as a staffer for then Senator Lou Leon Guerrero and for congressional delegates Robert Underwood and Madeline Bordallo. Before all that was before he went on to Yale Law School. He is the co-author of a forthcoming case book called Law in the U.S. Territories, a subject he has taught at both Yale and Columbia. In addition to his advocacy for the territories, Neil advises other nonprofit organizations on a broad range of legal compliance issues, previously working as an associate at the law firms of Loeb & Loeb and Treister, Ross, Shadler, and Gold. Prior to founding Equally American, Neil was litigation counsel and Supreme Court fellow at the Constitutional Accountability Center. Neil clerked for Justice Morgan Christen of the Alaska Supreme Court, and she is now a judge on the Ninth Circuit Court of Appeals. Neil was also a Thomas Emerson Fellow at the David Rosen and Associates in New Haven, Connecticut. As a law student, Neil successfully argued CCJEF versus Rel, a landmark case before the Connecticut Supreme Court, recognizing a right to adequate education for Connecticut school children. His commentary has appeared in the New York Times, CNN.com, Slate.com, and other media outlets. Neil also competed for Guam in the 1,500-meter race in the 2004 Athens Olympics. Ladies and gentlemen, Neil Weare.
Well, thank you so much for that great introduction, and it really is nice to be home back in Guam and back on the lovely campus of the University of Guam. Thank you, President Kreis, and I want to also thank the other organizers of this event today, Norma Annalista, David Okada and their team. Also really appreciate Attorney General Camacho for joining today in the conversation, and also happy to have my parents, Nancy and Bill Weir, here in the audience as well, and other friends. Appreciate their support throughout the years. So I want to talk about America's colonies problem today, and I'm going to do that in a few different parts. I'm going to start by talking about kind of my own personal journey through these issues, how my thinking and advocacy has developed and changed over time. And then I'm going to unpack a little bit more about, what do I mean by when I say America has a colonies problem? Then talk some about, what can we do about it, and what are some opportunities in the months ahead to try to take some action on addressing this issue. So just a bit more biographical information about myself. My family moved to Guam in 1989. I started in 4th grade at Harry S. Truman Elementary School in Santa Rita. Went on to then PD Middle School, on to Ocean View High School, and graduated from the first class at Southern High School in 1998. And when I was in high school, I really started thinking about these issues and seeing them because they were impacting myself and my classmates and my family. I mean, when I was turning 18, I had to sign up for Selective Service, which meant I could be drafted to go to war for the country, but I wouldn't be able to vote for the commander-in-chief and had no voting representation in Congress. And what I could just really see is that what I was reading in my high school textbooks, American government, US history, about America's democratic and constitutional principles, just didn't align with the lived experiences of the people of Guam and other US territories. As a high school student, and I actually, while I've been back this trip, I've been going through some of my old records, cleaning out the closet, trying to get things a little organized here at the house, and going through some of our old records. And one thing I came across that was kind of fun to see was testimony I wrote in support of HR 100, the Guam Commonwealth Act. That was happening while I was in high school. And actually got a letter of thanks back from then Congressman Robert Underwood, and even a letter from American Samoan Congressman Eni Fala-Mavenga, who's been a friend and colleague for many years as well. And so, I started getting fired up about these issues in high school even. Moving on to college, I went to college at Lewis and Clark in Portland, Oregon. And I really kind of went all in on this focus of international law, self-determination, decolonization. Was really passionate and excited about that. Going through my materials, I came across all these papers I wrote in college about self-determination. My thesis was on the weight of ideas in decolonization. I interned my first year in college for Congressman Underwood in Washington, D.C. And then I remember reaching out to him and saying, I want to come out and intern. Let's go protest on the steps of the Capitol about this. This is wrong. And he's kind of like, he's kind of a calm, relaxed guy. He's like, let's just calm down a little. Let's lower that down a little bit, Neil, and let's just try to do some, good work for the people of Guam. And while I was in college, I also spent a summer in Puerto Rico learning about these issues. Actually went out and protested at Vieques, where I was there the summer before the Navy left Vieques, where there was military bombardments and many health and environmental devastation caused by the military presence there. And then I joined the Guam delegation for the 2001 UN Regional Conference on Decolonization in Havana, Cuba. And that was with Governor Carl Gutierrez. And, he had a strong message for the UN, visit Guam. I guess some things don't change. That's his message today too, right? Congressman Eni Fala-Mavenga was there. He had a very different message for the UN. While Governor Gutierrez was talking about the need to decolonize Guam and address self-determination, Congressman Fala-Mavenga was insisting American Samoa is not a colony, that they're happy with their relationship with the United States. Moving on, and so that was kind of my, focus of these issues at an international level. While I was doing this UN work, I started to get a little frustrated because I just didn't think, I wasn't impressed that they were really going to act. This was the first decade on decolonization, and it was towards the end of that. And so I was thinking, oh, well, we're getting towards the end of the first decade. That must mean, kind of my naive sense, that must mean this is going to be resolved here soon. Now we're in, I think, the fourth decade of decolonization today. So kind of after that experience, I kind of thought, well, maybe, the local level is where change is needed. Maybe that's the best place to drive change. And so after college, I came home, worked on Robert Underwood's gubernatorial campaign, was really excited about him as a candidate because he actually cared about these issues. He talked about them. Voters maybe didn't prioritize these issues quite in the same way. I went on then to work for Lilian Guerrero when she was a majority leader in the legislature. And at the time, I just remember how excited I was that, well, the Guam Commonwealth Act process had gone through, and now the next thing was there was going to be a plebiscite vote. It was going to be scheduled for the next election. And then, well, it's going to be postponed. It's going to be scheduled for the next election after that. And then, well, maybe we'll do it the next election. And then finally, they're just like, let's postpone this thing basically indefinitely. And was just kind of like, wow, I really want to see this happen and progress move forward. And, wasn't seeing that kind of through the work that I had seen. And while working in the legislature, I just saw how many decisions that, most legislatures are involved with are actually end up being made in DC, that we didn't have control over a lot of the things that one would expect. And that these decisions on really kitchen table issues were made by people in DC, not on Guam. So I thought, well, maybe the federal level, maybe that's where we need to go to get some change. Maybe that's where it's going to happen. So I went out and worked for Congresswoman Bordallo in her first term. worked on a range of important issues, war claims, radiation exposure, SSI, Medicaid, still an issue back then, still an issue today. We'll talk more about that. And what I saw was just how hard it is to drive change in Washington when you don't have voting power, when you're a non-voting delegate, and just how the administration doesn't listen to you the same way when you don't have the same voting power as other American communities. And so then I kind of started getting a little frustrated with this federal level, like maybe this isn't where change can happen either. And so in kind of thinking about, well, where do I go from here? Started thinking about, well, how have other marginalized groups made progress, in American history, and came across a really great book called Simple Justice, which told the story about how Thurgood Marshall and other Black lawyers worked to overrule Plessy versus Ferguson and led up to Brown v. Board, which set the stage for the Civil Rights Movement and Voting Rights Act of 1960s and Civil Rights Acts, and really started drawing some comparisons of Plessy created this framework, this legal framework that allowed for racial segregation, and in the territories you had the Insular Cases, which again, based on the same kind of racism as Plessy versus Ferguson, established a legal framework that allowed for colonialism. But unlike Plessy, the Insular Cases had not been overruled. They remained on the books. They remained being cited by the United States, and they remained establishing this colonial framework over Guam and other territories. So that's when I thought, well, maybe I need to go to law school. Maybe law offers some kind of way to address these issues. And so in my application, I actually went back recently and was looking at my applications to law school, where I actually talk about, I want to go to law school to overrule the Insular Cases, talking about the disconnect between America's democratic and constitutional principles. And while in law school, continued working on these issues, was still waiting for this plebiscite to happen that we were all promised. Actually went out, started doing some writing on that, went to a conference organized by Dr. Michael Bevacqua at the Famixidzen conference, looking at, well, how can we overcome some of these procedural and legal issues that have kind of held back the plebiscite from happening. At the time in 2006, only 520 people had registered for the registry. There's been a lot of work since then to boost that number. Then after law school, I worked on the Obama campaign, clerked in Alaska, and but really wanted to focus on issues involving the territories. And so I went to a bunch of civil rights groups and said, hey, 3.6 million disenfranchised U.S. citizens, discrimination, inequality. These are all the things you guys are supposed to care about. Like, let's work to change that. And they're like, oh, we admire your passion. This is really important work. Unfortunately, because our donors aren't funding us to do this, we really just can't take it on. And so then I was like, oh, well, I should go talk to the donors then, like, see, get them to fund this, and then we can do this work. So I went and talked to a number of foundations and donors to say, hey, this is a big problem, racial justice. This is stuff on your website that you guys say you care about. And they're like, oh yeah, this is definitely super important. Thanks for bringing this to our attention. Unfortunately, none of our grantees are doing this work, so it's not something we can really support. And so I'm kind of left scratching my head a little bit at this kind of catch-22. And that's when eventually I kind of came around to the conclusion that's, well, if this work is going to get done, I just need to step up and do it myself. And that's when I founded my nonprofit organization, started out as We the People Project in 2013. And what I tried to do is take some of the lessons from that I'd learned through these different experiences to think about how can we maybe advance our advocacy in a different way that might lead to some different kinds of results. So using the civil rights approach that I'd read about in Simple Justice and learned about in law school. In Congress, I often saw how the territories wouldn't really work together, or sometimes work at cross purposes, like fighting over crumbs instead of working to change the systemic structures. So I thought, well, let's get all the territories to work together on these issues. We're stronger united than divided. Framing the issues in a way that your average US voter or congressperson could relate to and kind of bring them into the conversation. making it bipartisan, cross-ideological. Like this isn't a partisan issue, even as sometimes it's approached that way in DC. Working to create more of a national narrative around these issues. One of the early things we did was work with Last Week Tonight with John Oliver. Probably many of you have seen, his segment talking about the denial of voting rights in the Insular Cases, actually interviewing a number of the clients we represented in an earlier case. And then also engaging elite institutions and thought leaders. So we were able to get former Solicitor General Ted Olson to work with us, some prominent liberal lawyers, and then as the president mentioned, I taught at Yale Law School in Columbia, and they're doing special issues on the territories, their law reviews, so making some progress on that front. So, so that's kind of how that's kind of how my thinking has evolved over time and some of the different experiences I've had, which really has just kind of brought me to this conclusion over the last few years of really framing it and recognizing this as America has a colonies problem. When I first founded my nonprofit, kind of the word colony was kind of like a bad word or a dirty word that people didn't really want to use. And even some of the territories, folks would be like, well, we're not really a colony. It's like, maybe it's benign paternalism or maybe even benevolent paternalism, like at worst. And I feel like that has really started to change just in the last 5 or 6 years. I mean, with Guam, we've seen that kind of through the experience with the military buildup or even things like the Korean missile threat from a few years ago. The real turning point, though, I think was in 2016 when in the span of just 1 month, you had the Supreme Court say in US versus Sanchez Valle that there was no residual sovereignty in Puerto Rico, that all sovereignty in the territories rested not with the people of the territories, but in the halls of Congress. And then just a week later, the Supreme Court denied one of our cases saying that, well, because people in the territories are born on US sovereignty, that should come with certain rights, like recognition of citizenship. And then just a few weeks after that, Congress passed and the president signed into law the Promesa Bill, which essentially took away self-governance from Puerto Rico and put it in an unelected board that determines their budget, determines their taxes, and basically answers most of the questions that government is there to answer. And so people started thinking, well, maybe colony is not such a bad word to use. Maybe this really is an apt description. That really became clear in 2017, following Hurricanes Maria and Irma in Puerto Rico and the Virgin Islands. You had 3,000 deaths in Puerto Rico after the storm had left. So during the recovery, these are preventable deaths. And because of the failed federal support for recovery and assistance, you had thousands of people literally die. Then, of course, the image of President Trump throwing paper towels to citizens of Puerto Rico. And then in 2018, the president suggesting that the United States trade Puerto Rico for Greenland, like it's some kind of trading card or something. And then, of course, in Guam, I think a lot of these issues have really come to the head through the Davis v. Guam case, which was decided and made the exercise of self-determination all that much harder. So with, America has a colonies problem, the first part is admitting that you have a problem. And this is one of the things we really focus on in our advocacy is just getting the United States to own that yes, there is a colonies problem and that Washington and the federal government is the one who created it. So they have the responsibility to fix it. It's not just the responsibility of folks in the territories to fix for themselves. So you often hear a lot of excuses at the national level and in Congress. Well, Puerto Rico can't make up its mind. They're divided on the issue. So I guess that means we don't have to do anything. Or, Guam hasn't told us what we want. We're just waiting to hear what they want and we're happy to give it to them. You hear these excuses, but with the lack of meaningful federal engagement, it's no surprise that people are having difficulty making up their mind or expressing what it is that they want. There's not even real clarity on what is the current status. What does that mean? And if you don't know where you stand, how can you know where it is you want to go? What options are on the table? What would it mean? It's hard to make a decision in a vacuum without understanding what is even on the menu. Like, how are you going to choose what you want to order if it's not even described? And having there be real consequences of that decision. I mean, Guam has had so many different education campaigns on these issues, and one of the challenges is getting people to really engage. But that shouldn't be too surprising, because if people don't think anything's going to happen as a result of it, why would they spend their time and energy learning about something? I mean, if you had some hypothetical decision that would be made, it's a lot different than saying, do you want number one, number two, or number three? So there's a federal role that's much more needed to encourage this process and support this process and take ownership that America is the one that has a colonies problem, and they need to take action to get past that. So, well, what do we do about it? There's lots of tools and approaches to bringing about, social change and structural change. And, at Equal American, we're very much for the all of the above approach. By themselves, kind of each of these tools and approaches are necessary, but none of them are sufficient. There's no silver bullet here. If this was easy, it would have been done, decades ago. We wouldn't be approaching 125 years after 1898. And so there's a few different legal frameworks that you can approach these issues through. The civil rights approach, looking at things like the US Constitution, the Guam Organic Act, human rights, decolonization, self-determination through UN treaties and frameworks, indigenous rights, environmental justice, federal laws and local laws. And then even outside of law and policy, you have arts, culture, which I would argue are equally, if sometimes not more important than some of these more tangible legal or political approaches. And if you kind of had a Venn diagram of all of these different approaches, there's a tremendous amount of overlap between civil rights, human rights, indigenous rights, environmental approach. There are some tensions between them, between the different approaches, but on the whole, really, they each bring something unique and important to contribute. Our organization focuses on these issues primarily through the civil rights lens, but we support the work of other advocates who approach their work through primarily human rights lens or indigenous rights, environmental or other approach. And been very impressed with the work over the last 5 or 10 years here in Guam. People like Melvin Wampat, Dr. Michael Babakwa, and others, the Commission on Decolonization, who've done great work to address America's colonies problem through a human rights lens. And then others like Julie Nuggan, who's been a tireless advocate for addressing America's colonies problem through indigenous rights, environmental lens. And he's made even maybe more of an impact through the arts and his writing than even through these strictly legal approaches. So will advocates working on these issues always agree with each other with what's the best way to address America's colonies problem? No, they won't. And I actually think that that's a good thing. It's hard to predict what approach is really going to get traction and work, which one of them is going to stick. So having multiple different approaches increases the chances that something is actually going to make progress. And then there's also synergies that can develop between them. That can, we need a bigger tent. We need different partners and allies. So, what kind of opportunities are there today in trying to address these issues? And, kind of just as a framing, I would say that the advocacy opportunities in just the world has changed a lot just in the last few years following the tragic murder of George Floyd. You have kind of a new space for engaging in conversations about longstanding racial justice and systemic inequalities. You have individuals, institutions, and even federal officials, the president, Congress, much more open to having some of these difficult conversations that have been avoided for so many years. Revisiting even, some of the biases that they may have of, well, why haven't we been doing this for a long time? Or why haven't we been focusing on this? And that's been really exciting to see in our work. But I thought I'd just kind of talk through some of the things that we're doing through the civil rights framework to give some examples of what can be done. But also would welcome, during the question and answer, if folks in the audience or, listening in are welcome to share some of the work that they've been doing using other frameworks. And I know Attorney General Camacho has been using lots of different frameworks as well. So I thought I'd first start by talking about some of the work that's been done on federal benefits discrimination, because I think it really highlights some of the advantages of a civil rights approach for bringing about change. So a lot of you probably are familiar with the Supreme Court case that was argued last year, United States versus Madero, which involves whether Congress can deny SSI benefits to poor, disabled, and elderly citizens simply because they live in a US territory. There's a similar case here on Guam involving two twins, the Schaller twins, who tragically passed away before a decision was finally reached. Justice delayed, justice denied. And one of the things that's been exciting about this litigation is it really has forced the federal government to take a clear position on these matters. So with the legal case, when you have versus the United States, what that means is they have to show up and defend what the United States is doing. They have to justify what the law is or what the action is that you're challenging. And so as part of this, as the case was working its way to the Supreme Court, there was a change in administrations from the Trump administration to the Biden administration. And President Biden, as a candidate, had promised that he would stop defending the law would he be elected president. And so, we worked to hold him accountable to that. We worked with members of Congress, other allies to press the Biden administration to stop defending this discrimination. And that really put him on the spot, kind of put him in a box, like he had to take some kind of action to do something about this. Perhaps not surprisingly, DOJ continued to defend the case as they do in most situations, but he issued a very rare public statement when they filed their brief. Making the point that there shouldn't be second-class citizens in the United States, saying that he supported extending SSI and Medicaid. In fact, including the extension of that in the federal budget that he submitted to Congress. And he's again submitted it in his most recent budget. As part of the work around this, we worked to elevate the voices of people in each of the territories who'd been impacted by this discrimination through a campaign we called the I Am Jose campaign. We included even signs at the Supreme Court. We brought this all to the Supreme Court, Guahu si Jose, Yo soy Jose, trying to represent each of the different territories' experiences. One of the folks we heard from is the father of Haley Nicole Diamati. She's a young woman with Down syndrome who suffers from a range of different disorders, who's about to turn 18, at which time she'd be eligible for SSI benefits if she were living anywhere else than Guam. And it puts the family in a really difficult position to choose, do I make sure my child gets the benefits they need, even if that means that I have to move away from my family and support that is all she's ever known. We spoke with the family of Rachel Anafaji, a young girl who can't walk due to a rare combination of medical disorders, who's having to make these same kinds of decisions. We also talked with folks who were stuck stateside. So Sonny Titano, he had a heart liver transplant in California, wants nothing more than to come home in his remaining years to be with his family here in Guam, but he literally can't live without these federal benefits. And so he's put in this very difficult choice to have to make these kinds of really heart-wrenching decisions. And so we raised these stories, at a national level, at the Supreme Court, to members of Congress, to the White House. And we're excited to see that, there was the action being taken by the legislative branch. And so we were successful in getting this included in the Build Back Better Act, working with allies. But of course that didn't pass. And so, now the Supreme Court's soon to rule in the Madero case, possibly even as early as this week, certainly by the end of June. I think most court watchers think the case is not going to go favorably for the territories, that the court's likely to reverse the lower court decisions that ruled that this discrimination was unconstitutional, which then creates a window for action legislatively. If the Supreme Court says, well, this isn't something that the courts can resolve, this is Congress's job, that creates some energy to get Congress to finally act on these issues that Guam's delegates have been introducing bills on now for probably 30 or 40 years. And so it shows some of the force and power of impact litigation to get the political branches to act. And one example of kind of that being successful is a case that some of you might be familiar with, Lilly Ledbatter, involving discrimination against women in equal pay. Her case was not successful, but the first law that President Obama signed to law was the Lilly Ledbatter Act, addressing legislatively the problem that the Supreme Court did not address. And so there's an opportunity for something similar to happen here. Had some nice conversations today with Senator Tina Muñoz-Barnes, and I've talked with others, Governor Lou Leon Guerrero, and Congressman Mike Sinicolas, about how can we get Congress to act on these issues after so many years. We've also done a lot of work on trying to turn the page on the Insular Cases and the colonial framework that they established. One of the statements that really stuck for me from a recent event earlier this year, last year on Guam, from Congressman Robert Underwood, was that the Insular Cases, quote, encoded into the political DNA of the United States that colonies are okay. Something that the Attorney General said at one of the panels that really stuck with me is that the harm of the Insular Cases isn't hypothetical. Like, we see it in our kitchen table issues. We see it in the denial of SSI. We see it in all of these different things. So our organization has worked to address, to try to get the court to challenge the Insular Cases in some earlier Supreme Court cases, Aurelius case dealing with the Oversight Board in Puerto Rico. Next week, we're filing a petition to the Supreme Court in Fidesimano versus United States, where the Biden Department of Justice is actually cited to, not just cited to the Insular Cases, but actually cited to some of the most racist provisions in them, to argue that so-called unincorporated territories are not part of the United States for purposes of the Citizenship Clause. Now, there's differences in viewpoint among different folks on the case. Elected officials in American Samoa have opposed the case, supporting the United States view that only Congress can decide questions of citizenship, while current and former elected officials in other territories have supported recognizing a right to citizenship. But regardless, there is this growing pressure on the Biden administration to stop relying on Plessy-era Supreme Court decisions that have been relied upon to deny rights to people in the territories. We worked with a group of members of Congress who wrote the president earlier in the year, calling on him to condemn the Insular Cases. We recently worked with a group of prominent civil rights organizations to do the same. Legislatively, Congress is considering a resolution to condemn the Insular Cases. The Guam legislature passed a similar resolution earlier this year, or last year. We've also worked on a number of things pressing for the right to vote and expanding territorial voting rights. So to kind of wrap things up and bring things together, ultimately, America's colonies problem requires a kind of serious dialogue and introspection at both the national level and in each of the territories. The people of the United States must ask themselves, who are we? Who do we want to be? And what does that mean regarding our relationship with residents of US territories? And the people of Guam and other territories must ask themselves, who are we and who do we want to be? And what does that mean regarding our relationship with the United States? There's no easy answers here, and it's a difficult, sometimes uncomfortable conversation, but it's really a very necessary conversation. My hope is that all sides can come together to reject the colonial status quo. It's time for the people of Guam and other territories to decide through a process of self-determination, decolonization, whether they wish to be equal or independent, equal citizens under the US flag, or equal sovereigns separate from the United States. Either option I think is not only viable, but would offer dramatic improvements over the status quo that would enhance quality of life on Guam. It's time for Guam and other territories to be equal or independent. Now, I wanted to introduce Attorney General Camacho here to come on the stage and have a little bit of a conversation about these issues and kind of hear some of his thoughts on America's colonies problem. He's someone who spent his time both in government and outside government working to address America's colonies problem in really direct ways. And he's done so using just about every framework that I talked about. On the civil rights side, he was our co-counsel in Segovia versus United States, a Voting Rights Act case involving overseas voting. He led a really exciting amicus brief in the Valle Madero case, where he brought together Guam, the Northern Mariana Islands, DC, and 15 states to argue against continued discrimination against residents of the territories. He's been very much involved from a human rights and indigenous rights perspective, being one of the leaders in Weir Guahan, successfully protecting the CHamoru Land Trust and supporting self-determination and decolonization. And then even on the environmental side, Safe Southern Guam, and a lot of work he's done to help protect Guam's environment and some of the colonial legacy of destruction that's present there. So I welcome Attorney General Camacho to join me and give his reflections on this idea that America has a colonies problem and what we can all do about it, and look forward to talking more with him about it.
Always the bad student. I showed up and they asked me if I had notes, and I said, I'm just going to show up and wing it. I'll take this off just for a little bit. And I cut myself shaving. So if I look like Nelly, for those of you who are old enough to remember Nelly, that's the reason why. I will say I'm CHamoru, and my journey has been a little bit different than Neil's. And growing up, we didn't talk about territories and colonies and things like that. I remember in 11th grade, we were asked to write a persuasive essay, and I turned it in, and mine was called The Organic Act of Guam. And my teacher, Miss Abade, looked at me and she said, I hope this is more interesting than the title. But at that point, you start wondering, we didn't have Guam history when back in the day. I mean, I say that as though I'm old, but we learned geography, we learned about the Marianas, but we didn't learn about the history of the island, including the colonial history. I was intent on becoming a lawyer, didn't know why. And I decided I would do something else. So in my junior year of college, and I'm speaking to the university students, for those of you who aren't overachievers, and Neil has always been an overachiever. Walter, his brother, has always been, and Mr. and Mrs. Weir, Dr. Weir, your children are amazing. They've done fantastic things. And I'm glad to say that I beat Neil in cross-country meet one time. So I beat an Olympian, and I remind him of that every opportunity that I get. But I decided I didn't want to go to law school. I want to do something more practical. I was going to become a literature major. And my mom kind of lost her cool when I told her that. But I was really into romantic literature, and I can still cite, She Walks in Beauty Like the Night. And I remember taking literature Black America course as a requirement. And part of it was we were required to read Fanon, Black Skin, White Masks, and you should read this Albert Memmi book. And I started thinking about law and structure. And again, this is someone who grew up in Guam, had been in university at that point for 3 years, and just had no idea how to deal with what I had experienced growing up in Guam. I ended up getting into a seminar, and the entire quarter we spent reading W.B. Du Bois, The Souls of Black Folk, and the concept of double consciousness. And that inspired me to write. I'm not a very good student, but I did my essay on Ramon Sablan, Dr. Ramon Sablan, the composer of the Guam hymn. And when he wrote it in English, and everyone knows, he wrote it in English, it wasn't translated to Chamorro, Whanogi Chamorro till the 70s. And I did like a literary look at the change in the words from English to Chamorro and what it meant, how it was an act of protest to every single word selection, every single word choice was deliberate. And I remember reading Dr. Ramon Sablan, this is in the 20s, he's asking Chamorros, are we fish or fowl, right? And you think about just to read that and never see that growing up in Guam and start to understand and discover yourself in college. And I have to just recognize the university, because you guys who are in school now are way better off than when most of us, or I say that as a 40-year-old, and I see Dr. Cruz back there. We were 8th grade students together. And after I graduated, I came back home. I taught for 1 year. I taught science at FB Leon Guerrero in the same school, in the same class that I had been in 8th grade. And I remember the first day opening the book, and it was one of our classmates we were still using the science book. And at that time, I was looking to get loan forgiveness for teachers. And I looked up, okay, what schools in Guam qualify as a low-income school? Every single public school in Guam qualifies as a low-income school. So I came back home, I taught, and I thought, I love teaching. I love being with kids. I love, it's still one of the greatest experiences of my life was teaching for that 1 year. But I thought there was a different way that I can make an impact. So I took a year off. I was a social worker in Seattle while I studied for the LSAT. Ended up going to Boston, and in law school, I wasn't smart enough to make a law journal, but I was interested in this area. So I decided to write my note on interregnums, which, for Guam, it's a very precise thing where the president has executive authority to acquire a territory, but under Article 4, Congress has the authority to make rules and regulations. So in between the time that the president acquires a territory and Congress takes action, that's what they call an interregnum. So a lot of these cases is dealing with extraterritorial acquisition, and we're talking about a short period. So I was interested, Guam had a 52-year long interregnum where we were governed by an executive order that's about a paragraph long until we got our Organic Act in 1950. And that was I was interested in. Was it unconstitutional? Because that's rooted in the wartime power to acquire a territory to then govern under naval administration for decades. So after that, graduated from law school, I had the privilege of working and clerking for Chief Justice Carbolito. And again, he's a very tempered man. And I remember reading his remarks when they created the Supreme Court of Guam. There was a probationary period for the local attorneys because they didn't trust us to make judicial decisions that we had to report to the Ninth Circuit. And again, as Chief Justice Carbolito was the most tempered man, but I think he used words like paternalism and just very strong language for your honor. And it just struck me as here we are in 1996, using the same type of logic that the people in the territories, despite their education, don't know how to govern themselves. And it wasn't extended to just, I gave a presentation this afternoon to my son's third grade class, and the first quiz was, when did we get our 3 branches of government? Right? I mean, you ask kids that, and they're like, oh, I don't know, when we were required, no, 1950, we get our legislature, 1970, we elect our first governor, 1996, we get our Supreme Court of Guam. I mean, all of this is relatively new in terms of our experience here. So when we talk about colonialism, it's not something that's old. And for me, again, I'm not a theoretical person. I'm very much a meat and potatoes type of person. So Weir at Guahan was, I like running in Jigo. They're going to close my running trail. I'm going to show up to a reading group and I'm going to see what happens next. And that kind of snowballed. And you end up becoming an expert in environmental law, or at least learning a little bit about NEPA. And then from there, you have CGMT. And I just want to recognize Mayor Adon. It's kind of off topic, but CGMT, the CNMI Joint Military Training Complex, POGAN, and everything that's going out there. And it's like these conversations are all interconnected, like our political status and what happens in our islands, Guam, American Samoa, Northern Mariana Islands, Virgin Islands. We all have these connected stories. So it's just by chance I find myself in these opportunities to use my profession to do what I initially set out to do, which is to be an advocate for the people of Guam. And I will say that when 2012, Justice Sotomayor came to Guam, and this is something, Your Honor, too, we brought this up. So 2012, Justice Sotomayor comes to Guam. She leaves during our presentation on the Insular Cases, and she does a site visit to the dump. I'm sure in the back of her mind, she never was thinking 10 years, 9 years from now, I'm going to be ruling on a case involving whether or not Guam can proceed in its case to hold the Navy accountable for paying its fair share of the dump. And at that presentation, we had a great panel. I would never have thought, flash forward 2018, and bear with me for those of you who are present at our Guam Bar presentation. We had the chief judge from Puerto Rico was here, and he was talking about when will Congress's deference over the territories end, right? And he threw in a note, there's a new case that just got filed involving a citizen from New York who's moved to Puerto Rico and has been sued by the federal government to collect the money he received in SSI. And then the government realized they made a mistake. You messed around, they're about to find out. So they tried to dismiss the case and he wouldn't let it happen. He actually kept jurisdiction over it, but he flagged it as something that is going on 2018. And I get sworn in 2019, things are happening. We find out he rules that SSI and excluding Puerto Ricans from it violates equal protection. He applies strict scrutiny, which is the highest standard, says it's racist and it's ethnically based to exclude Puerto Ricans from this program. And it's, it takes the courage of judicial officers. And when Neil was talking about the likelihood that the Supreme Court's going to say this is Congress's issue to fix, it just ignores the complicity that the judicial branch has played in the situation that we're in today. They created the Insular Cases. They created the extension doctrine. They've been applying this idea of what is fundamental and what is not. And then to punt and to say, well, now it's a political decision after you've wrecked a century of havoc on the citizens and residents of the territories, it's just too easy of an out. And it's probably going to happen that way, but it doesn't get us to where we need to be as a community to get closure for these terrible cases. So goes up in the circuit. Judge Torreya is the opinion, and he affirms the district court decision. And I'm not going to bore you with the legal stuff, but if you can read it, and if you're into law, it's masterful, his opinion in the circuit. And we're in a position now, we get a call from the DC office, and they know that we're interested in this issue. We have been working, I see Rodney Jacob back there, the champion of justice. I want to recognize him for his work in the Schaller case, because as Valle Madero is working its way up in the circuit, Rodney and his team are working their way up in the Schaller case, which is just, as lawyers say it's a great fact pattern, but it's a terrible situation where you have twin sisters, same ailment, want to be together, and one gets SSI and one doesn't. You just could not think of a less equitable situation than that. And that's what we're fighting for, right? You have people in Guam who are receiving 10 times less than what they would be receiving if they were living anywhere else. You have people who cannot move back home because losing those benefits means that they cannot pay their rent or their power or the utilities, right? So we got a call from the DC office, their Solicitor General, and they have an entire division devoted to Supreme Court appellate practice. We got to work with them. We drafted a brief. We had talked to Rodney and his team to make sure that we're all aligned. We're not taking a position that's going to jeopardize what's going on in the Ninth Circuit, in our circuit. And I will tell you that there is nothing more nerve-wracking to send out a draft brief to your colleagues, the other attorneys general across the country, and then you just wait to see who's going to join you, right? And I remember the first one we got back was Maryland, General Brian Frosch out of Maryland. And it's just like, what does Maryland care about SSI? And I asked him at a meeting, and he said, we don't know about this. We don't hear about this. We don't know as lawyers, as chief legal officers for our states, that they have anti-poverty programs where people who are excluded from them in Guam, and you take a 40-minute, maybe 40-minute flight to NMI, and magically it applies to you. And the best thing that we got NMI to join, General Manabusan from NMI to join. And people will ask, well, why are they vested in this decision? They receive SSI. And the NMI basically had to choose, which anti-poverty programs do you want? Which needy populations do you want to help? Do you want to help the elderly, blind, and disabled? Or do you want to help the needy families? And I say that because we don't get SSI, but we get SNAP. NMI gets SSI, but no SNAP. And that's the way it is. And we use this analogy. It's like pulling names out of a hat. Okay, SNAP, you're going to go here. SSI, you're going to go here. And then to work and to get our colleagues together who, again, just are unaware of what the state of the law is for the territories. I'm excited. I'm not optimistic, but I'm excited because I believe this is the first time the Supreme Court will issue a decision on this area, in decades. And I just point out, I was asked this morning by third graders, who is my favorite justice? And I said, Thurgood Marshall, because every opportunity he was given to stand up for the territories, he did. Guam versus Olson, he was the dissenting opinion. So this may not mean much to anybody else, but there are thousands of people in Guam who care about this and who need a Supreme Court. And he was in the dissenting opinion there. You have Califano, again, dissenting. Harris, dissenting. And he actually, for those of you, again, getting into the procedural, they denied or they upheld the exclusion of people receiving benefits in the territories without even allowing briefing, without allowing the advocates for the territories to set foot in the door to argue how irrational it would be to deny anti-poverty programs to the residents of their respective territories. So we are at a truly historic moment in time that not only has there been briefing, not only has there been argument, but the Supreme Court, in one way or the other, big picture is going to have to decide how much deference do we give Congress when it comes to the territories, and potentially have to deal with the issue of the Insular Cases. And Neil is aware that the American Samoa, the citizenship cases, every one of these is going to be tension. Everyone, just because you don't know, there's all this uncertainty, there's all this fear about what's going to happen if the Insular Cases get overturned. What does it mean? And whatever the answer is, we're going to have an answer. So this generation of future lawyers or whatever you choose, future artists, you're going to have a Supreme Court opinion saying fish or fowl. What are we? And be able to hopefully fuel some change, whether it's through the courts or another vehicle. So again, it's kind of weird and morbid to say that I'm excited to be in this moment in history, but I can say I never would have imagined 10 years ago when Sotomayor was here that the Supreme Court would have granted cert to address the issue of whether or not Congress can arbitrarily, deny territories benefits, and we'll go from there. And I will, as much as I kind of point out the judiciary's role in this, but Judge Gelpi, Judge Tydingle Gatewood in Guam also struck down SSI as being unconstitutional, and the circuit, if Judge Torreya did not affirm, there's no way this would have gotten up before SCOTUS, right? He had to be, and again, I say it's masterful because we have precedent saying SSI doesn't apply to the territories per curiam opinion, but it was ruled on an interstate travel. So he's like thread the needle legally to get us to the point where he obeyed Supreme Court precedent, but created an opportunity to advance an argument on behalf of the territories. And again, I think it's fitting that that was the last opinion Judge Torreya issued in his position, and Judge Gelpi was appointed to replace him in that spot. So it'll be a legacy spot. I don't really, I know I have 5 minutes. I'm always brief in all things that I do. So Neil, I just want to tee up on the American Samoa case. And this is often the question that we're asked, what happens when you have the former Attorney General of American Samoa was arguing against Neil in their case. And you have Judge Torreya in the Valle Madero case distinguishing this fact pattern, saying the democratically elected government of American Samoa doesn't want citizenship. So just to start the Q&A, Neil, how do you respond to that type of argument?
Yeah, no, I appreciate it. And the American Samoa case is a case we actually first brought now basically 10 years ago, the first version of the case. And I had in developing the legal theory and developing the case, went out and met with communities of American Samoans in American Samoa, in California, in Seattle, in Hawaii, talking with them about how do you feel about citizenship? How does it impact your lives? Hearing from people who had their lives impacted in really serious ways. One woman living in American Samoa had a baby, and unfortunately the baby had a heart defect that required constant medical supervision, wasn't available in American Samoa. They had to go to Hawaii for the medical care. Her husband was a foreign national, so as a non-citizen national, she wasn't able to sponsor him to come with their daughter who was receiving this medical care the way she would have been able to if she were recognized as a citizen. And so they're put in this choice to decide, do we have our daughter receive the medical care she needs, or do we keep our family together? And sometimes you hear some elected officials in American Samoa say, well, you can just choose to naturalize. That process would have taken so long that situation wouldn't have been resolved in that period of time. And I heard so many stories like this from people who, one of our own plaintiffs faced a similar story where he was a Vietnam veteran. And when asked to say, well, why don't you just go through the naturalization process? He said, well, I did everything I was supposed to do when I served in Vietnam, and the helicopter I was serving in got blown up by a missile. I've got 2 Purple Hearts. That's all I should need to be recognized as a citizen. And the question of citizenship and individual rights like citizenship, it's a very different question from these broader questions of self-determination and decolonization. So our case is a very narrow legal question as a technical matter, asks what does in the United States mean for purposes of the citizenship clause. It doesn't ask, nor does it answer what American Samoa's future relationship with the United States should be. It doesn't, it leaves that question properly to the people of American Samoa. So that's the question for self-determination on these issues, not should marriage equality apply in a territory or not. That's another position that the American Samoan government has taken to say, even after Obergefell, recent Supreme Court decision, that marriage equality doesn't apply because of the insular cases. You've seen some people make similar arguments about the right to abortion or other individual rights. This kind of idea that under the insular cases, it can be this kind of grab bag. And ultimately, if you look at these lower court decisions, the insular cases and these lower court decisions, it's not at all about deference to the territories. Really, the rule that comes through is it's deference to Congress, deference to the federal government. So, here in this citizenship litigation, the American Samoa government's taking the same side as the United States, saying that this is a question that Congress gets to decide. And the federal courts are agreeing with them, suggesting that, isn't this great that the federal courts are following the position of what the territory wants. But then you see a case like Davis versus Guam. Well, what the people of Guam wanted in that case was very different from what the federal government's position was. And in that case, who won? Wasn't the territories, it was the federal government's position. And if you look at case after case, really this is what the insular cases stand for, is that Congress has near unrestricted powers to, as we may find out, as you said, really almost arbitrarily discriminate. So it's not, in law school, they talk about this rational basis standard, the lowest standard. They sometimes say, well, under certain circumstances, it has rational basis with bite that like maybe will be a little bit more searching in what we look at. But this is like rational basis without bite, without even looking at, even when the factors are clearly arbitrary, there's no justification for why SSI should apply in the Northern Mariana Islands, but not Guam, or why Guam should get SNAP, but not them. There's no justification to it. But the courts may well say, well, that's enough for us. If Congress wants to do it, regardless what the people in the Northern Mariana Islands or Guam or American Samoa think, Congress is always right. And that's the nub of what's so dangerous about the insular cases and the colonial framework that they establish, is that even when they appear to be providing some kind of recognition of the preferences of the people of the territories, what they're really doing is solidifying this continuation of this colonial framework, and that it's necessary in order to dismantle the colonial structure in the territories, to dismantle legal frameworks like the insular cases, just as it was necessary to bring an end to racial segregation and address civil rights in the African-American community, to move on beyond Plessy. At the end of the day, there's a lot of complexities involved in these conversations. Happy to dig into some more of those, if folks have questions, but also just interested in hearing more, as I said, from folks who are approaching these issues from different perspectives, and some of the opportunities and challenges that they've had, and what are some opportunities that may be coming up in the future, because this is a really exciting time we're in right now, where a lot of these issues that historically have been worked on for years and decades are seeming to come to some kind of head. And I think that's where it's really important for the community to come together and try to take as much advantage of this moment that we have, because who knows how long it's going to last. And so seeing what can be done in the next years and months, I think is going to be exciting for all the students at the University of Guam and all the others in the community working on these issues.
Thank you very much, Attorney Weir and Attorney General Leevin Camacho. Round of applause. Ladies and gentlemen, we're also honored to have with us tonight Mr. Melvin Wanpat Borja, who is the Executive Director for the Commission on Decolonization, the President of the Department of CHamoru Affairs, and the Acting Director for the Guam Public Library System. Thank you for joining us, sir. And logged online is Mr. Edward G. Perez, retired Brigadier General, former Chair of the UOG Board of Regents. Round of applause. So ladies and gentlemen, we are going to open the floor for questions. We will start with our audience here tonight, and then we will also get some questions from our webinar. So let's start with the audience here. Are there any questions? Hazel and Shar, our advancement associates, have the microphone, and we kindly ask that when you ask your questions to please keep your masks on. Questions from the audience? Sir.
Thanks for your comments, Neil and Attorney General Camacho. They're really helpful and gave context to what I consider both a problem but an opportunity. So I really share that idea with you. One of the things I want to follow up from General Camacho is the responsibility of the courts. Having really worked hard and litigated in this area, the thing that is undeniable is that the courts created this problem, and the modern courts, particularly in our circuit, are really fond of saying what I think General Camacho articulated, which is, this is a really, 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 really bad problem, but we can't help you. And I just want to ask you, what strategies do you think are available to us as next steps? And before I answer that question, I want to give you current information about the case that I did, the Schaller twins case. Unfortunately, Dr. Federer's twin sister-in-law passed away. And today the Ninth Circuit decided the motion by the United States, which asked the court to vacate, to direct Judge Gatewood to vacate the judgment. We opposed that and told the circuit that this was an unusual situation, that it was of public importance to allow that decision to stand, even though it may not benefit the folks. And the Ninth Circuit today in a paragraph said no and directed the court to dismiss and vacate. So, what do you do with that? Because I was reminded today of really what I feel is an application of the federal court's responsibilities to really right this wrong. I mean, my own personal view is it's just a call to continue fighting it out. But what do you do about it, and what's the next step?
Thanks, Rod. I just want to, Rod, Attorney Jacob, in 2012 when Sotomayor came out, we used Judge Gelpi's presentation, and the one thing that we added to ours were slides on benefit programs, and that was Rodney urging us to talk about Medicare and Medicaid. We cited to the GAO report how one patient in the NMI used up their entire Medicare cap for the island. One patient, anyway. So Rod has been in particular, when you talk about coming out from different ways, for me, it's moral identity. What does it mean to be a colonized person? For Rodney, it's about helping those who are needy and those who need benefits. And that was the angle that, again, Rodney, I'm sure you wouldn't have guessed that we would be arguing in front of the Supreme Court. In terms of what we do next, there has to be fuel to the fire, right? And when Neil talks about how we have to have broad advocacy, lawyers can only do so much, and most people don't like lawyers to begin with. So it's hard for us to be the beacons of hope for anyone when we're naturally risk averse and kind of downers when you invite us to your parties. So this is really going to take political action and organizing. I've seen it in the Davis case. You've seen it with the CHamoru Land Trust case. And we have, again, when we talk about the university students, like the youth are just so engaged on these issues. And then people just need to explain it to them though. Like, this is what this actually means. We have a court saying this. The sovereignty case with Puerto Rico, it was a double jeopardy case. I mean, it wasn't exactly the most salacious of fact patterns, but it was like, there is no sovereignty before the United States, Puerto Rico. You tell it to Puerto Ricans and they get a little bit fired up about it, right? So that's where our job as lawyers is to connect that messaging, to explain like why you should care. Why should someone care that the Ninth Circuit did that? Why should someone care that the Supreme Court, because they're going to sanitize it. And we have a line in our amicus that they have laundered this doctrine through time, through less objectionable cases, right? So you're going to say, oh, it's SSI, this is the way we're going to do it. But they cite to a case that was extremely racist in the reasoning. So that's what we've done. The further away we move in time, it's just a single citation, and that citation carries so much weight historically. And that's really our role, is to unpack that for people and to get them motivated.
Yeah, and I'd say too that, even cases that don't end with a victory have still served an incredibly important function. First, just for telling these people's stories, just as a vehicle for telling the story of the Schaller twins for others to hear, for telling the story of Mr. Vaio Madero, of telling the story of John Fidisimanu. That in and of itself is very important. But even beyond that, providing a platform for broader engagement on these issues. So, as I talked a little bit about, would President Biden have said the things he did and taken the actions he ended up taking in the absence of the Vaio Madero case and the other cases like the Schaller case and other cases in Puerto Rico? I absolutely think not. I think there's almost a near zero chance that things would have advanced as far as they have legislatively, but for the pressure, public pressure, legal pressure, policy pressure that came from those cases. And then I think the other thing that we've seen, over the last 5 to 10 years is that as much as some of the lower courts don't want to grapple with these issues, or as much as the Supreme Court doesn't want to take up these issues, when we keep pressing, even when there are defeats, we keep going, we keep fighting. Eventually they start coming along. And so, in the Aurelius case, Puerto Rico Oversight Board, we pressed them hard to, overrule the Insular cases. We worked with counsel in the case to, first time at oral argument, to the justices' faces saying it's time to overrule the Insular cases. And they're very dismissive in that case. This time in Vaio Madero at the oral argument, the Chief Justice said, oh, the Insular cases aren't really relevant here, are they, counsel? The United States has said, no, they're not really relevant here. We recognize equal protection applies. And then you had Justice Gorsuch step in and say, well, like, maybe it's time to overrule the Insular cases then. They're incorrectly decided. And so you see kind of how these continued efforts in these different cases have come together to create momentum and energy in the courts, certainly, but in political spaces, in a national conversation. The story, last week, tonight, that story, that came from them learning about our citizenship case and that there are people born on US soil who weren't being recognized as citizens and being disenfranchised. That's how they learned about it. And we worked with them to tell an even broader story about the territories. So that's one of the powers that, litigation and the courts can have in really elevating the voices of just real people who are going through real issues and facing the impacts of discrimination and ongoing colonialism. And for whatever reason, those, this stories and this platform and this kind of mechanism tends to stick a little bit more even than, maybe some other means. And so I think that, I applaud you for your work on the case, for raising their stories, and, we'll see when the decision comes down. Whichever way it goes, it was a success in my book.
Okay, thank you for that question, Attorney Jacobs. Is there any other question from the audience? We have a question at the back.
That's loud. Guys, thank you so much for everything you shared. I actually have 2 questions. One was when you were talking about the people in American Samoa kind of reacting to wanting U.S. citizenship, and that the example you gave was a woman who wanted better health care, but it would take too long to be naturalized. Are there also conversations about how instead of naturalization, how can independence allow for that? So allowing the country to develop its own healthcare system and kind of what are the conversations around independence in American Samoa? The next question was, I was really interested in this idea that Congress could act on things the courts wouldn't act on, but then I was listening to Attorney Rodney talk about the court saying, this is really wrong, but we don't want you, right? So where then does action actually take place, particularly with the Davis case? So could Congress define that Native inhabitants are entitled to this vote, and would that override the decision in the Davis case particularly?
Yeah, I can start with the first one. So, I mean, this is one thing that's interesting about American Samoa. It's a little bit different than Guam or Puerto Rico, that there really isn't an independence movement to speak of there. They've actually had kind of opportunities, maybe more so than even some other territories, to pursue that. Their kind of sister islands, when it was a colony, Western Samoa, now independent Samoa, was a territory, I think, of New Zealand, and then became independent. And there were conversations around that time period of, well, does the people of American Samoa want to join? And you could, bring these islands and people back together. And it was a very clear answer that no, they didn't want to go that path. They want to remain a U.S. territory. You have Congressman Palingvenga, you have their lieutenant governor and former AG Ale testifying at the United Nations saying, we're not a colony. We're happy with this relationship with the United States. There's certainly issues we want to improve upon. But that's one of the things that's kind of strange about this dynamic, is you have, on the one hand, people who are proud Americans, proud to be part of the United States, but raising concerns about citizenship because of uncertainties of how it could impact land and culture. That the legal connections just really aren't clear to how exactly that would materialize. So yeah, and that's something that I think is an important point that our American Samoan co-counsel Charles Alaima always emphasizes, is to say, let's have a serious conversation about self-determination. Let's decide whether we want to be part of the United States or not. That's the conversation that we should be having. That's what's decolonization. That's the self-determination framework. Let's not be having conversations about picking and choosing which individual constitutional rights apply. And on this, I don't know, do you want to jump in on the second question or comment on the first one?
Well, it's just, those are connected, right? Like if Congress has the ability to potentially suspend the 15th Amendment, then you're acknowledging Congress's basic absolute authority over the territories. So that is where there's tension. I know that the answer is the lawyerly answer. It depends. And it really could go either way. And that goes back to American Samoa, and just, there is uncertainty as to what would happen if the Insular Cases are overturned. We know there's a constitution, but then if we go to Article 4, can Congress suspend the 15th Amendment? I mean, I don't know if this is the Supreme Court. I would want to advance that argument. So is there a chance you would prevail? Possibly. Is there a chance that you wouldn't? Absolutely. But again, that's two sides of the same coin, right? Like if Congress can say, this is the group we're going to allow to participate in the plebiscite, then Congress can also say Guam's out when it comes to federal benefits. So those are interconnected and just very, that's where the real work happens, right? It's like, what do you want to do? You want to push on one thing at the potential expense of others in terms of Congress. And this is, this is the second time where I've done a presentation on like the fourth branch of government, right? In Guam, it's like Congress. Congress is our fourth branch, and ultimately the ultimate branch of government. They get to control everything from our Organic Act on down. So I don't know how to answer that. I would say it's very unlikely that a court would say Congress can suspend the 15th Amendment. The way around it would be to come up, and this is kind of what the Ninth Circuit alluded to in the Davis case, which is absent the legislative history of that bill itself. There was a stronger argument that it was not a race-based category, it was a political category, right? But when you have, it's called, CHamoru, and then in the wake of Rice versus Cayetano, now all of a sudden you're doing things, and then the legislature is saying things. And the Ninth Circuit, I'd say in a pretty sympathetic opinion, kind of acknowledged a lot of that and just said, we're kind of tied with the record that we have in front of us. But if you would hit reset and gone back and we're going to allow everyone who received citizenship through the Organic Act and their descendants, I mean, I think that's a much tougher argument. Very different than I remember Julian talking about Rice and had a picture of like Captain Cook, right? And that's what we're talking about for the way they defined Native Hawaiian. We're talking 1950 for us.
Yeah, and I would just kind of add on to that, my reading of the Davis case is that I think it is narrower in some respects than some people read it as, and that I think it does leave open legislative options, not just at the federal level, but even at the local level to, as Attorney General Camacho said, hit reset, develop a better definition, develop a better approach, that anticipates some of the legal arguments that might come in perhaps a more effective way, and kind of not take no for an answer. It's not. I think that there's ways to continue to shape and change that conversation to move forward as well.
Thank you for that question, Lola Leon Guerrero. Now we have over 100 people logged on watching this webinar online, and we want to get to the questions that are posted on the chat. So I'd like to ask for just one more question from the audience, if there is any. Yes?
First of all, my name is Jim McDonald. I am the board chairman for Guam-raised Stoppers. And I want to welcome my friend here. He's the director for Region 14, U.S. National Crime Stoppers Board. And I'm also we were both voted and approved in December. And I am the regional director for Region 12, which represents the states of Montana, Wyoming, North and South Dakota. And my friend here is the director for Region 14, and he represents the states of Alaska, Washington State, Oregon, and Idaho. And the reason why I brought him here, we've been here, thank you, Dr. Price, for having your criminal justice students. We were invited there a couple of days ago, and to talk about crime and how we can lesson learned from Mr. Ed Badal here, my friend. He's Hawaiian, a native Hawaiian who lives in Alaska, and he has a lot of experience. And guess what, guys? He knows a lot of politicians also in Alaska. So that's why I bring him here. I said, I'm sorry, but I have a passion also, because I come from a family of military. And Neil, I've been reading up on you. Leevin, you're my nephew. I've been communicating with you, and I think there's, everything's interrelated, even crime and law. So, I just wanted to welcome my friend here, Mr. Ed Badal. But if you guys want to talk to him about politicians in Alaska and those states he represents, he's open. And he's here in Guam now.
They have voting representation there and we don't, so we have to talk to him, right?
Yes, that's what I said.
Thank you, Mr. McDonald. We are going to the chat to ask the questions next for Attorney Weir and Attorney General Camacho. The first question comes from Phil Leon Guerrero, and he asks, do you believe the federal government, whether through Congress or the courts, would approve a native-only plebiscite for non-self-governing territories like Guam?
I can take a stab, I guess. I think it goes back a little bit to the earlier question that I think it would be great, as I talked about in my presentation, it's always great when Congress helps empower and support these kinds of efforts. But we also don't have to wait to Congress to do that. That I think there is a path in the Ninth Circuit's decision that leaves some flexibility for Guam to establish and pursue self-determination, through some tweaks and adjustments to the way it was approached before. So, if we're going to be waiting for Congress to act on something like this, I think we'll be waiting a long time. And I mean, something else that has just struck me, now as I'm, both Attorney General Camacho and I are, getting further along in our careers. It's been more than 20 years since I started working on these issues and being so excited about the self-determination vote. It's about to happen. It's going to be the next election. And how much longer do we really want to wait? And how much longer do we want to, so anything that kind of adds time and delay to it, I just really, wonder if that ends up being worth it, if there may be other paths forward.
And I would just, it took 52 years for Congress to act, just to establish an organic act. If they were to do anything in the realm of self-determination, it would be in response to something. They're not going to just do it. It has to be some movement. And again, it's not going to be through the courts. It's going to require some pressure politically through allies, or here in Guam, again, just creating the dialogue and pushing.
Well, and that's something that, I mean, it's not going to happen through the courts, but the courts have an important role in creating that pressure. So, having a Supreme Court say that the colonial framework in the Insular Cases is rejected, to say that, this idea that the United States can have perpetual colonies, that's so inconsistent with America's founding ideals and the history of territories from 1776 to 1898. Those kinds of statements from the court can help, as in Brown v. Board, the Supreme Court called on the political branches to act with all deliberate speed. It didn't immediately impose a rule that they had to follow. It engaged the political branches in working to address this historical injustice. And so again, and this kind of goes back to the point that Attorney Jacobs and Attorney General Camacho made, is that the courts are responsible for establishing these problems, but for the Insular Cases, we would have a very different history of territorial development for Puerto Rico, Guam, and the other territories. Like the political branches at the time were, pushing full speed ahead on, let's have colonies. And they knew that the ultimate question would be answered by the courts of whether that was permitted or not. It hadn't been permitted anywhere else in American history. And had the courts, had Justice John Marshall Harlan been in the majority instead of the dissent in the Insular Cases, we would have had a very different history there. Just as we would have had in Plessy versus Ferguson, Justice Harlan's dissent been the majority. We've seen his dissent in Plessy now become the majority decision through Brown. We're still waiting for that moment when it comes to the Insular Cases. And we heard recently, soon to be Justice Jackson at her hearing, in addition to talking about the Guam case and how she got that right. And 9 justices agreed with her and Attorney General Camacho. She also talked about, in response to a question about how Justice Harlan laid a blueprint through his decision, his dissent in Plessy, that lawyers then were able to follow, and eventually the Supreme Court was able to move forward. And it was exciting to hear her talk about that kind of blueprint as she now steps into a seat where she will be addressing some of these issues that were addressed in Justice Harlan's Insular Cases dissents. And so my hope is that same trajectory and path could be followed in this circumstance too.